Chair is entering your report, Your Honor.
Thank you. All right, juror number 11, I understand you are my foreperson.
Yes.
Can you hand the verdict to my bailiff? Thank you. Mr. Juror, Ms. Garrett, you want to rise with Mr. King? Madam Clerk, will you publish the verdict?
In the Circuit Court of the 6th Judicial Circuit of the State of Florida, in and for Pasco County, case number 2018 CF 435 CFAXWS, the State of Florida versus Qiu Feng, indictment for count 1, murder in the first degree verdict. We, the jury, find as follows. The defendant is guilty of murder in the first degree as charged in the indictment. If and only if you find the defendant guilty of murder in the first degree, beyond a reasonable doubt, you must also find if the defendant did discharge a firearm causing the death of Edward Lee Tudor, the answer is yes. So say we all this 14th day of August, 2019, signature of the foreperson, C11.
Does the defense wish the jury to be polled?
Yes, please.
All right, ladies and gentlemen of the jury, they're going to read the seat number that you're in, and the answer to that is whether the verdict that was read is in fact your verdict, yes or no.
Juror number 1, is the verdict rendered your verdict?
Yes.
Juror number 2, is the verdict rendered your verdict?
Yes.
Juror number 3, is the verdict rendered your verdict?
Yes.
Juror number 4, is the verdict rendered your verdict?
Yes.
Juror number 5, is the verdict rendered your verdict?
Yes.
Juror number 6, is the verdict rendered your verdict?
Yes.
Juror number 7, is the verdict rendered your verdict? Juror number 8, is the verdict rendered your verdict?
Yes.
Juror number 9, is the verdict rendered your verdict?
Yes.
Juror number 10, is the verdict rendered your verdict?
Yes.
Juror number 11, is the verdict rendered your verdict?
Yes.
Juror number 12, is the verdict rendered your verdict?
Yes.
Thank you, Madam Clerk. All right, ladies and gentlemen of the jury, I want to thank you for your time and attention in this difficult type of case. I also wish to advise you of some very special privileges enjoyed by you as jurors. No juror can ever be required to talk about the discussions that have occurred in the jury room except by court order. For many centuries, our society has relied on jurors for consideration in such difficult cases. We have recognized for hundreds of years that your jury deliberations, discussions, and votes should remain your private affairs as long as you wish it. Therefore, the law gives you a unique privilege not to speak about your jury work. Although you are now at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone about them. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you individually to decide whether to preserve your privacy as jurors. All the rules about tweeting, texting, or blogging are lifted, so if you want to go home and tell everybody about the fine time you had here working on this case, and Twitter or Facebook or whatever social media, you're more than welcome to do that. If people ask you a question, you can just tell them you don't want to talk about it. So it's completely up to you individually. I have a certificate of appreciation for each of you. If you want to go ahead and take your juror badge and go ahead and put it down in front of you. At this time, I'm going to excuse you as a juror in this matter. If you would like to remain and watch anything that the sentencing afterwards, you're more than welcome to do that. We'll just have you gather your things and you can have a seat in the back. If you do not wish to stay, you do not have to. You're more than welcome to just go on home for the day. But we are going to move on to the sentencing phase. I don't know if we're going to complete it today or pick another day, because I have to talk to the lawyers about that since I hadn't gotten the verdict yet. But if you want to watch, remain and watch, you're more than welcome to do that. All right? So thank you very much for your time and attention. I have a certificate of appreciation, and we are going to have to give you your cell phones back this time, though. Sorry. All right, Mr. Pure, Ms. Garrett, if you want to approach with Mr. Key to the podium for me. Mr. Pure, does, due to the indictment, the jury's decision, and the verdict form, there's only one sentence for the court to impose. So I don't know if you're ready to proceed with that today.
Judge, we are, Mr. Key is entitled to a pre-sentence investigation under due to the charge and verdict, and due to the fact that he has no prior record. However, Mr. Key wishes to waive his right to a pre-sentence investigation and a pre-sentence report, and wishes to be sentenced today, so we can initiate the
Okay.
proceeding.
State, are you ready to proceed with sentencing today?
Yes, Judge.
All right, do you have members of the victim's family that wish to speak to the court before I proceed with sentencing?
No, Judge.
All right, and based on the law and the decision of the jury, at this time, Mr. Key, in case number 18 CF 40435 CF, I'll adjudicate you guilty of murder in the first degree, and the only sentence that the court can impose in this case is life without the possibility of parole. So at this time, I'm going to sentence you to life without the possibility of parole. And can you afford to hire an attorney for an appeal? Okay. I know that there was a civil verdict against any of the assets that you hold outside of the court. So at this time, I'm going to find that you're also indigent for appeal purposes and appoint the public defender for appeal. Is there anything else the state would like the court to impose, any other costs, restitution and whatnot?
No, Judge.
All right, so there's the normal $550 of court costs and fines and $250 for the Office of the Public Defender. Mr. Pure, does your client waive any breakdown of those costs?
Yes, he does.
All right, and then there's $100 to the state. I'm not going to impose any surcharges in this matter. Those will be imposed as a lien against him and on 30 days to appeal. Mr. Keith, thank you very much, sir. I need a score sheet, but you just write right on it. So we have one. You do need to file one, but the only reason is in case for any appellate purposes, they need to know what the score sheet is. Both sets of lawyers for an excellent job. I know these kind of cases are very difficult, and you all did an excellent job.
Thank you. Do you need the court here right now?
No, you can, just as long as you file it, just send it to my office. Other than that, I'll have all the evidence back, and we'll be adjourned.